Good afternoon. Welcome to the Simply Biz chat. Before we begin, can you please just let me know if everyone can hear us and see us? Anybody? Perfect, brilliant. It looks like we're live and well. Okay, so this is a sobering talk. It's not a comfortable decision. It's not an easy thing to do, but retrenchment is a reality, particularly in the current circumstances. So we're here to try and make it a little bit easier for you. My background is human resources and Leigh is a labour lawyer. And we're just hoping to simplify it a little bit and give you some guidance on how to get through what's going to be a tough time for you and for your employees. As we go forward, please do feel like you can ask questions. We're quite happy to stop and entertain a question. You can pop them into the chat section, or you can put them into the questions, whichever works for you. This is called a DIY retrenchment toolkit. So the suggestion is that if you follow the processes, that you will be able to do it by yourself. If you are having trouble, if it's something that gets a bit more complicated, then obviously we'll give you our details at the end. The slideshow will also be available. You will get a link to see this. So we're hoping that all the resources will be there for you to actually manage a fairly difficult process. Okay, so just to begin with, these are the laws that govern retrenchment in this country. We are quite a highly regulated country, and particularly when it comes to labour law, very regulated. And the idea here is there are two aspects. It's procedural and it's substantive. So you have to follow the rules that are set down and you have to stick to them. There's no halfway house. And substantively, so from a perspective of a reasonable man, okay, granted, we know they don't exist, but from the perspective of a reasonable man, would this be substantively a fair thing to do? So please just bear those two concepts in mind. The DIY toolkit, we are working on the assumption that because this is a small business presentation, that most of you would have less than 50 employees. If that's not the case, please do contact Allardyce and Partners. They will help you through, because then section 189A comes into play and it gets a little bit more technical and a little bit more difficult to do by yourself. Okay, so please just bear that in mind, that this is for section 189 for those businesses for less than 50 employees.
Thank you, Jan. I just want to follow up on what Jan has said regarding the substantive fairness. When you have dealing with a retrenchment, or perhaps contemplating retrenchment, your reasons for the retrenchment are incredibly important. Today, we're not going to deal primarily with the reasons, because usually at this stage, by the time that you are contemplating retrenchment, there is sufficient reason, whether it be financial, you don't have enough money, whether it be structural or technological. So what we're going to deal with today is primarily the procedural aspects, how you go about the retrenchment. So the first thing that you need to do is you need to establish what will be the basic terms and conditions that you need to have a look at in line with the provisions of section 189. And the first thing is you need to decide whether or not it is only the contract of employment. Remember, if there is no written contract of employment, it will default to the Basic Conditions of Employment Act. And where there is a written contract and it is more favorable, then the written contract terms and conditions will apply, especially in respect of severance. The large organizations generally will have a collective bargaining agreement, which means that it's an agreement that is concluded between an employer's organizations and the unions, as opposed to just an individual and the employer. You may also have a main agreement, which is where there's an extension of the collective agreement, and it does not apply just to the individual employer and union. Rather, it is extended across the sector. So, for example, if you are a single or a sole proprietor carrying on business as a panel beater, you need to be aware that you may be a member of the main agreement, which is under MIPCO, and in that case, you need to have consideration of the main agreement as the terms and conditions to basic conditions of employment act. So that's your very first point that you need.
So Leigh, I think that's actually quite an important point to put across, because a lot of small businesses assume, oh, I'm a small business, collective bargaining doesn't actually apply to me. Unfortunately, the way our law is set up, if these agreements are in place on a collective basis, the collective will take place, will supersede the individual contract. So it really is important to actually find out if you are in any way affected by a collective agreement, and catering.
Set up catering companies or organizations. And often you need to
So it looks like we dropped there. Please just let us know if we're still back on. Perfect, thank you.
Sorry about that. What I was saying about the catering, in many cases, individuals will start a catering business. And in some cases, they'll pay the bargaining council dues without even realizing that they are, in fact, a member of the bargaining council. And in fact, guys, you are supposed to be a member of the bargaining council. And in that case, there is a main agreement which applies, and it is extended to even parties to the agreement. So please be aware of your specific industry. Check whether or not you are, in fact, liable under a main agreement. And that is very important, because if you're not, then your procedure is going to be flawed from the outset.
Okay. So very thought. So on that note, would you actually just explain to us about the notice period? Because we were chatting about this with the onset of COVID. What represents a written notice is a little bit different from what it used to be.
Quite so. In fact, the courts have actually found that you may give notice in any form of writing. In fact, in exceptional circumstances, this may be done away with, but please do not go there for now. The written notice can be via your WhatsApp, can be by email, can even be by SMS. Suffice that it is, in fact, compliant with the provisions of Section 189, and more particularly Section 189, subsection 3, which provides what must be contained in the notice. Now, the one thing that is very important as well is that when does this notice have to be given? Please remember that as soon as you contemplate, or as soon thereafter as is reasonable, you need to notify your employees that their retrenchment may be possible. Very often, recently I've had it where people during the COVID, employers rather, during the COVID period, have continually communicated with their employees. And they've done this via WhatsApp and SMS just to keep them informed as to what has happened. And that then led to written notices in terms of 189. And ultimately, in fact, a lot of the processes were concluded by WhatsApp, even going so far as the settlement agreements, voluntary retrenchment agreements.
Quite surprising. I mean, WhatsApp actually now being a legally accepted document. It's quite fascinating, but of course that's because you then have the record. So it has changed things the way, IT is now becoming a part and parcel of the law, we would have thought. I see we have a question here from Monique. The question is, where do you check if you're subject to a bargaining council?
Thank you, Monique. Very, very good question. The first thing to do is go onto Google and have a look at your sector. In fact, ask the question. If, for example, I'm a catering company, am I bound by a main agreement, or am I supposed to be a member of a bargaining council? And if so, which bargaining council? So in that case, for example, it would be the bargaining council for the tea room and restaurant industry. So thank you for the question. Very important.
Yeah.
Okay. All right. The reason that I started with trying to advise you about to look at your agreements, your contracts, is because when you issue the notice to your employees, if you are subject to a collective agreement, the notice then has to be given to the union who is party to that collective agreement. Just a word of warning now, due to the movement of minor unions and the incursion, you need to make sure that from a cautionary point of view, that you actually give notice to all the employees with their unions, majority and the minority unions, so that you avoid any dispute about not giving notice to the correct party and or not consulting with the correct party. Because if you fail to do so, it will be procedurally unfair.
So that's actually quite an interesting point then, Leigh, that this is an area you can easily slip up and through no fault of your own, unless you haven't done the homework. I always remember my law lecturer saying it's like scoring a home goal, something nobody wants to do. Okay, if you can stick to the rules and overprotect yourself on the procedural side, it makes your case that bit easier, that bit stronger. And also the rules are there so that everybody knows what's expected. So to follow them and don't leave yourself vulnerable. So in this particular case, what we're really saying is overtell. Tell everybody, in fact. Don't just sort of say, okay, well, I'm only thinking of retrenching Joe Bloggs, and you only give the letter to Joe Bloggs, because you could well be inadvertently denying him the right to representation from a union representative who's from a minor union. So rather cover yourself on that particular one. Thank you. I see we have a question. I'll quickly go across there.
While Janet's looking at that question, something to bear in mind is that sometimes the question gets asked if I'm only retrenching or contemplating the retrenchment of one employee, so do I have to tell my other employees? I think that for best practice and for transparency, it is important to do so. Obviously, you have the difficult scenario where morale is affected, and Janet will deal more in depth with that a bit later, but rather advise everyone what you are doing, as well as the reasons why you are doing it.
Yeah, good point. I see Megan asked, how does the court decide what is a reasonable reason for retrenchment? Megan, I will be covering that in a moment or two, so if I can just pause that question, I will get to that one. And then Monique has asked, is the onus on the employee to tell you that they're part of a major or minor union? No, the onus isn't. You have to err on the side of rather find out for yourself, okay? So ask and go looking for that information. The courts tend to protect employees. So just always assume, effectively, that the onus is on you and not on your employees. Would you agree?
Definitely. Yeah. And Monique, something else, as a general rule, an employer, when you have recognized a union, will deduct the union dues that are owing by any employee and pay it over to the union. So you would usually know the union in your organization. Sometimes there are minority unions who come in who you don't recognize or you don't know about. Hence, when you give the employee the notice in terms of 189, you will be asking them, one of the questions is their representation in the consultative process. And that would include maybe asking them to notify you of any union membership.
And you will find in the toolkit that is available in Simply Biz, and will also be available through the Gear Down handbook, that these things are there. We've put these little steps in so you know, okay, I need to checklist this, I need to find out. So yeah, rather err on the side of caution. Okay, so Megan, I will be now getting to your question. Okay, so I put here this picture of a checklist particularly because it's not actually a checklist. Okay, so yes, you do have to make sure you cover every single point that is required by law. That's the procedural aspect. But this is where the substantive side starts to come in. The contents of the notice really now start speaking to, is this retrenchment actually fair or not? So I'm just going to quickly go through some of the points and then we'll unpack it in the next slide. So the reasons for the proposed dismissals, and believe it or not, you cannot just say COVID-19. I mean, to the average person, that would be answer enough, surely. We're all devastated by what's been happening in this pandemic. Businesses are closing, unemployment's rising. Why do I need to substantiate? Because you need to prove the case from your business. Okay, not just from what's happening in the greater economy. It has to be particular to your business and your chances of recovery or not if you don't do this retrenchment. So the next point there is the alternatives that the employer has considered and the alternatives that the staff may put forward. And that's a very important thing, that retrenchment has to be a last resort. You need to have shown that you have looked at reduced hours, part-time, furloughs, maybe that you have actually taken relief from the various government's offerings that there were during, such as TERS. But there needs to have been a genuine effort on the behalf of the employer to have actually avoided retrenchment. So that's very, very important that you include those alternatives before you actually mention retrenchment. The number of employees who are likely to be affected. Obviously, in a smaller business, it's an easier process to manage. But it might be, for example, that you have two departments and you have decided that the one department actually is the one you don't need because you've now gone remote, and this was the walk-in counter or whatever it might have been. But you need to be able to make that connection between why the retrenchment and why you can't use them elsewhere. And we will talk a bit more about that. The proposed criteria, very important. Are you doing LIFO, last in, first out, or FIFO, first in, first out? What are the reasons? The likely date, so you're not necessarily going to be announcing it tomorrow. If you are a Section 189A, which is for bigger companies, and there is a whole process laid out that you have to follow a certain time period, doesn't quite apply with the Section 189 as long as it's reasonable. Again, back to that, how long is a piece of string? Can you show that you did listen, that you did look at alternatives, and it wasn't just the next day these people are being fired? I think that is really the way to go. So the likely dates that it will happen, obviously, and the proposed severance pay. We'll unpack that, so I'm not going to go there just yet. And then obviously the assistance offered to employees, which again, I'm not going to talk about on this next slide. So the key here is that it's more than a checklist, that you actually really have to have applied your mind to what goes into that letter. You have to have shown that you have considered alternatives. The reasons for the retrenchment. So Megan, this is very much talking to your point here. It's about a balance of probabilities. So that means if, it's the juggling act, basically. But I have to listen to what you say, and I have to believe, and I'm coming up with an arbitrary figure here, that 60% of what you say actually makes sense. So would a reasonable person, seeing that I'm just going to take, for example, that your sales are down to almost nothing. Okay, you can show the trajectory of your sales. You can show that your main clients have actually closed up shop. You can show that there is no foreseeable short-term turnaround for you, and that you have looked at things. Those are the kinds of considerations that will actually weigh either in your favor or against your favor. So I hope that answers that. So it is really, it's not checklist. It's I have tried everything in my power to avoid this retrenchment. And this is how my business has been impacted by COVID, or by whatever it is that has impacted you. It could be a technological change. Let's take the taxi industry. They were slaughtered by Uber, literally slaughtered. And that was a technological change. And so those kinds of things can literally turn your business upside down overnight. As long as you can prove that, then you have a reasonable case of the court accepting, on a balance of probabilities, that this was a reason to retrench, and that it isn't just a way of getting rid of dead wood. And I want to emphasize this retrenchment process at any time can never be a reason to performance manage. This is not the time when you go out there after that guy who you've always just not been happy with. Their performance, could be better. And you just haven't had the wherewithal or the energy to actually performance manage this person properly. It is very obvious to any commissioner or any court when this has happened. And you are laying yourself open to all sorts of allegations of victimization and you name it. Just don't go there. Okay. Stay true, stay fair, stay reasonable. And that then goes to the concepts of the criteria. So the criteria, one of the ones that is most generally applied is the last in, first out. So if you are the most recent employee, you should, by most argument, be the most vulnerable in terms of being let go. Unless there is a real genuine reason. So it could be that because of a technological change, that now this person just does not have the skill, or this department doesn't have the skill. Hi, I hope we're back. Please, can you just acknowledge if we are here? Phew, okay. Thank you. Alrighty. Doesn't matter how many times you test, Murphy will have its way. Okay. So I think I was talking about selection criteria. I'll just go back a little step because I'm not quite sure when we actually dropped. So the selection criteria that is often put forward is LIFO, which is last in, first out. But there could be a variety of different options, and I mentioned that the technological skills might be an option, etc. I don't know, Leigh, would you like to chip in on that?
No, you're quite right. But whatever criteria you use, please remember it must be objective and it must be fair. So what Jan was saying about the employees who are not performing, in a recent case, the Labour Court actually said that it may be a factor. It's not the criteria, but you may have a look at it. However, I would caution against it if you don't know what you are doing, because you do not want to have a court find your process flawed, that you were in fact using retrenchment to performance manage a person out. So yes, your selection criteria can be a combination. It could be something like LIFO together with skill set. It could be skills or perhaps even a combination of a great many, depending on each business's operational requirements, as long as you can prove that they are objective and that they are fair.
Just on that note, it's not COVID, just clearing my throat. Okay. So I see that we had a question there from Michaela. What if I can't afford to pay a severance package? Really good question. Thank you. Sadly, it is one that has come up a few times. I know a number of people who've been exactly in this boat. They made the decision to try, eke out, keep on going, and eventually they've had to call it a day, but they've now gotten to a point where there's literally not enough money, even after selling assets, to actually pay out a full severance pay. So to just take a little step backwards on that one, so severance pay requires a number of things. So you first have to pay for the time worked. So if you're owing salary for the month, whatever, obviously up until the period. You also need to pay notice pay. Now it does vary on your contract, and it also varies on length of service. But for example, the average being the 4 weeks is your notice pay. You might have leave that is outstanding that you would need to pay out. And again, depending on your contractual requirements, there could be issues with bonuses, with pensions, you name it. So a lot has to be factored into what constitutes this severance package. But this is the kicker. The kicker comes because in terms of the Basic Conditions of Employment Act, hold me true, it is the Basic Conditions of Employment Act, or the BCEA, you are generally required to pay 1 week. 1 week's pay for every completed year of service. Again, there are exceptions. I'm just trying to give you the nub here. So if you've had an employee who's worked for you for 20 years, that's a good deal of severance pay that you're going to have to pay out. Now, legally, you have no option. But this is the rub. If there's no money, then what happens? Would you like to come in on the liquidation? Yeah.
Look, just something to bear in mind, touching on what Jan has said, you need to check your contracts of employment and or any policies and or your collective agreements and or your main agreements. Because in many collective agreements, and particularly main agreements, the severance is not 1 week for every completed year. It is, in fact, more. Often it's 2 weeks. Sometimes in some contracts, of individual contracts even, I've seen 3-4 weeks severance benefits. So please be careful to check that firstly. Secondly, with regard to the question about what happens if I can't afford to pay, please remember that an employer saying to a court that I cannot afford to pay is not sufficient to get you out of trouble. There are a number of different options. Some companies are simply ceasing to trade. Please remember that if you are a sole proprietor or a partner, the individual employee has a right of claim against you. They can go to the CCMA and they can refer a dispute for severance, non-payment of severance benefits. Perhaps they would even include an unfair dismissal. In a case like that, because these are statutory monies that are due, they are non-negotiable. They will be made payable by you if you are a sole proprietor or a partner. If you are a company or a closed corporation, obviously you have other factors like needing to deregister with the company's master's office and or SARS. But similarly, you would need to, in fact, have one of two things that can happen. Either go into business rescue or declare insolvency, and that may be by way of the courts, by liquidation. The claim then for the employee doesn't go away because there's no money. The claim is then a claim against the liquidated estate. The employee has the right to approach the civil courts as well for non-payment of these monies. That, however, is a long-winded and very expensive affair. So most employees will go directly to the CCMA, which is very quick.
Yeah. I think it is important, though, to note that if you're going through a liquidation process, preferred creditors, those who are, such as a bonded debt, will get paid out before employees get paid out. So yes, they are high up in terms of the food chain, in terms of, if there are any assets left that then actually get paid out, but preferred creditors do come first. So yeah, there's no escaping it, but there's only so much money in the pot, and the pot starts at the top with preferred creditors down to employees. And then, for example, SARS comes straight after employees, and then all the other creditors will get paid out. Yeah, okay. So I see we have a question here. In terms of skill set, this is from Monique, by the way, is there a requirement for you to upskill or train the employee before you use it as a reason for retrenchment? What happens if I don't have money for additional training? Really, really great question. And again, so relevant to where we are at. If the company is in distress, it is a given that you don't have money. So yes, by all means, look at options. So there can be, training doesn't have to be expensive. And, look at what Simply Biz is doing at the moment. There is a lot of free stuff on the internet at the moment. So if you can show you have attempted to guide your employees and you have given them opportunities to do training online, in the workplace, in your work time, that kind of thing, that would be a genuine effort to help them, to sort of see them into the future kind of thing. But it is certainly not a requirement that you have to actually fork out a fortune in expensive training if you're in trouble already. I don't know if you would like to add.
Monique, it is a great question because first and foremost, there is no legal obligation on an employer to train an employee for the job that he was hired for. In the event that you are engaging in structural changes, clearly your skill sets will then become very important. And what is important to remember is the alternatives to retrenchment. Retrenchment is a last resort. So if you can show, or the employee proposes it, because very often it would be a proposal from the employee, as an alternative to retrenching them, that they be upskilled or retrained for a specific structure that you have now decided on. That is actually a very good alternative if it is sustainable and it's in consideration of the business operational requirements. There is no legal obligation on you, however, to do so. What will generally happen is where there is structural change to an organization, and that structural change requires certain skill sets, and I'm going to give you the most basic that we all know. You are a typist, you use the old-fashioned manual typing machine, and now you need to use these incredible technological advances and computer, AI, VCs, etc. Some people are not trained for it. Some people can't be trained. Some people don't even want to be trained for those particular positions and or skills. So generally, what would happen in the restructure is you may be invited to apply for your own job, the job that you've been performing for the last however many years. And sometimes, and very often, you may not even be successful in that application for your own job. What is important to bear in mind is that the employer, if they can show that the skills that you have are not sufficient, or you're not the most suitable candidate, they do not have to then give you that position, even if you were, in fact, the incumbent of that position before. But please bear in mind, as Janet was talking earlier about the reasonableness, the underlying principle of fairness must be considered at all times. So is it fair to expect that person to fulfill a particular role without the necessary skills or training? More often than not, no. Is the obligation on the employer to provide the training required and or upskill? Generally, no, because you are hired for a specific reason to be able to do the job. You're hired because you are able to do the job. However, in the new organization, it may be more cost effective for an employer, when considering this as an alternative, to keep the internal staff and rather to upskill them. So when an employer is faced with this as a proposed alternative, you need to consider it very seriously, and very important, if you reject it, you must have objective reason for the rejection. You cannot simply say, no, you don't have the skills, you're out. So it is something to bear in mind. The other thing, Monique, is that it's suggested that the employer also looks at every alternative, even before you contemplate retrenchment. In some cases, it may even be during the retrenchment process, bearing in mind that the whole point behind the process is to avoid retrenchment if possible, if not minimize the number of retrenchments.
Yeah, and I think that's really is an important point, is does it have to be an all or nothing? Can you change things in any way? And as long as you can show that you have applied your mind and that you have looked at these, and I think this is now sort of jumping a little ahead to what Leigh is going to be speaking to, but you may find in that once you've issued this letter and you have started consulting with staff, that they come up with some suggestion that you have not considered, and you are then legally required to consider it. But I'm going to let Leigh speak to that.
All right, just bear in mind the slide before, we were essentially, there are, if you need to consider this entire process from not only the employer's perspective, you need to consider it from the employee's perspective as well. So we have made provision for you, not only the notice, it's simply a template, but it also provides you with a guideline on how to conduct these consultations. Now, I'm going to go on to the actual consultations with who must you consult with. Please remember what I said right at the outset. If there is a union that is involved, you need to consult with the union on behalf of its members. Bear in mind, if there's a collective agreement or a main agreement, that union may represent other members or employees who don't or who are not necessarily members of the union itself. So it's just something to bear in mind. That is a very important facet of the Section 189A, hence why Janet was saying to you it's a more complicated process. Now, the other thing to remember is this is not a negotiation process, it's a consultation process. By that, I mean that the employer reserves the prerogative to retrench at the end of the day. The purpose behind the consultation, as it's defined in the Act, is a joint consensus-seeking exercise. In other words, both parties attempt to reach agreement on the respective indicators in the 189 notice. If at the end of the day you cannot reach agreement, the employer is entitled to retrench, and obviously subject to proving that it was for fair reason and that he followed fair procedure. Something else to bear in mind is don't not participate. Or if you start participating, decide to leave because you don't want to hear what the employer's got to say, then you lose the right to complain about procedural unfairness. The employer is entitled to continue and will do so and proceed to conclude the retrenchment with or without you if you decide not to participate. The other thing is the question that gets asked very often is, how many consultations? Well, there is no hard and fast rule. You will note that when you engage in a retrenchment process, it's going to be a to-in and fro-in. Remember that if any one of your employees provides you with representations made in writing, you are legally obliged to comply and respond in writing. It's also advisable that during these consultation processes or times, you make sure that you have detailed notes, minutes of the actual contents of the consultation, because your record keeping is vitally important in these circumstances. How many? Well, it all depends on the circumstances. Sometimes I've had scenarios where the employees are all fully aware of what's going on in the business, and they've been party most to what's the business requirements, operational requirements. They know and understand that the business needs to either close down or perhaps restructure or downsize. And they've engaged in voluntary retrenchment agreements right from the outset. And that's at the first consultation. So you don't know. And the purpose behind the consultation is that the contents of 189 is not a checklist. It's not a tick off, I've done it, I'm happy, I've complied. No, it's actually that you participate, actively engage, consider and reject or accept, etc. The other question that often gets asked, and going back to what Jan was saying about the timelines, obviously the timelines in respect of your large organizations employing more than 50 employees, that is predetermined for you and you have to comply with it in terms of 189A. In a 189 scenario, which is most of the people who are involved today, the timeline depends on the company's business. If you have no money, you've had no money for the past, 142 days of lockdown, and you've got no work coming in and you have no projects, no hope for any work in the future, clearly you're going to need to do something urgently, today, if possible. So please bear in mind that each case is looked at on its own merits. What does that employer and that employee have to do and comply with?
So I'm just going to ask a quick thing. For those of you who are with us right now, are any of you actually retrenching at the moment, or have you already retrenched? If you could just pop it into the chat, just sort of let me know if anyone's actually had this experience yet. I'll give you a minute or two because I know there's often a bit of a lag before the typing comes through. Okay, so Kieran has said yes. Said no. Yes and no. Okay, I think it was a no. All right. Okay, so it looks like nobody's actually experienced it yet. I'll just keep an eye on the chat and see if that changes. The thing with retrenchment, and this is really now the HR side of me speaking, is that there are three victims in any retrenchment. There's the obvious victim, it's the person who's losing their job. And as the picture tries to sort of denote there, it's hectic feelings of rejection, of failure, fear of the future, and I have to go and tell my family that I don't know how I'm going to keep a roof over our heads, put food on the table. It can be dire. It's a terrible, terrible place for the person being retrenched. Then you've got the people who are left behind, those of you who are maybe retrenching just a few to try and keep onto the business. it's even sad for them. And these were their friends, these are their colleagues, and they start suffering from what we call survivor guilt. So nobody's in a good space in that particular environment. And at the back of their mind is the, am I next? So they've got the sword of Damocles hanging over them, and that's going to paralyze them. It's going to put them into a fear place, never a great place to be. But I think the one that we all forget about, and I'm really now speaking to you as the business owner, is that you are also a victim. Okay, this is your dream that's now in danger. You are the one who has to sit across from someone and actually tell them you're going to have to let them go. And that is a horrible thing to do, because we all know the reality. We all know what the jobless situation is like out there. And it's a very, very painful, very stressful thing to do. Personally, in my own immediate circle of friends, I know 5 people who are running businesses who have had to let go a number of staff. One business, they've been going for 32 years. They have gone from 25 members of staff to 2. Okay. The one, though, that was perhaps the hardest to actually help her through this was a lady. She's a graphic designer, and she works from home, and she and her employee have worked together for 25 years. So she's got a room in her house that is sort of separate for the business. They literally sit across the desk from each other. They have worked together for 25 years. So already last year she was battling with the downturn in the economy, and she'd already put her employee onto limited hours, onto part-time hours. She's now having to actually completely close the business. There is just not enough business. And she phoned me that day, absolutely distraught, devastated. And I think we need to just be aware of that it's hard for everybody. This is not an easy thing to do. So this is where you really have to become the leader. You have to actually dig deep for the resources that you have. And make sure you've been legally compliant, and we've covered most of the compliance issues here for you. But at the end of the day, you've also got to actually dig into your compassion. How can you make it as easy as possible? What can you do to help? Even if your business has run out of money, that's fine. You can't afford to train, but you can help them find free training. You can help them put their CV together. You can advertise for them that they are, put together a brilliant resume, whatever it might be. But what can you do to help and to actually make this as less painful as possible? For those who are staying behind, again, they're looking to you. They're fearful, and they're worried, and they're demotivated. And no one's working, and everyone's sort of in a semi-paralysis state. You really need to be the one who's leading from the front, that, you know what, we've had a tough time. You need to have that very much an open door policy on this, or an open screen, as it may be, if you're still working remotely. But you need to be available to employees, and you need to allow them to talk to you about how they're feeling and about their fears. And I think it's also very important for them to see your vulnerability, that you're also taking strain, that this wasn't an easy thing for you to do. So this really is, it's tap into that human side and be human during the whole process. There's also a side that people tend to forget about, and that is your suppliers and your creditors. This is now your brand, it's your personal brand, and it's also your company brand if you are actually hoping to still stay in business after the retrenchment process. What legacy are you putting out there? Are you doing simply I close the doors one night and I'm gone? Is that the legacy you want to leave, apart from the legal issues? How do you communicate what you're going through with your customers? And I know that quite a few of the speakers have been addressing this issue of actually needing to put forward a public message about this is what's happened, but this is what we're doing, we're still in business. But people are also aware of the fact that they've dealt with Sue in sales for the past 5 years, and now Sue isn't around. So the way you have that conversation with your suppliers and your customers is important, because they're also going to be watching to see how did you handle this. And at the end of the day, we all hope and pray that the economy will improve And so down the line, these people could also now be back in your industry. You need to be able to keep that reputation and that relationship going as positively as possible. And there's also nothing wrong with checking in with the person after the retrenchment. In fact, I really recommend it, especially if this person has worked for you for a number of years. Find out how they're doing. Be a human being. Reach out as much as you possibly can, and see how you can possibly help. Even if it is just to say, look, I will pass on your CV. Let me know how things are going. Keep those channels of communication going throughout the whole process, and be real. Be aware of the fact that you are taking strain, and so are they. And again, a lot of the people who've been speaking about the psychological side of COVID during the shifting gears and during the back of business campaigns that have been running on Simply Biz have been talking about tapping into your network. It is so important that you use your network to maybe help people find work, but to help you, to actually understand that you're not actually going through this alone. Get help when you need it. Go to a doctor if you need to. Don't face something as stressful as this by yourself. It is not a comfortable place to be. Okay. So we've effectively come to the end of our sort of formal presentation. This is the toolkit in a nutshell. You'll be seeing the slides there. All of these are downloadable. They are on the Simply Biz website. Most of them are in the Gear Down Handbook. And the Gear Down Handbook will be revised. We'll add more as we add more to the website. We will also keep adding things to the Gear Down Handbook. But it is there. You can very much do this by yourself. But if you are concerned, if you think that you might be involved in a collective agreement and you're uncertain, please do reach out to us. We will try and help as much as possible. Obviously, we also have to make a living. So we hope you can do it by yourself. But if not, we are available. And in fact, Leigh and I together are offering, as part of our give back, that the first 3 Simply Biz members who contact us by email and who quote Shifting Gears, you will be entitled to receive a 20-minute virtual consultation from us. And we will hopefully be able to help you with any of the questions that you might have while you're going through what's really a horrible process. So we are at the end. Please, as I say, do feel that you can contact us. And that's a goodbye from me.
Thank you. Goodbye from me.
Okay. Thank you.